Hello and welcome everyone to our latest Fenwick Elliott webinar. My name is Stacey Sinclair and we are delighted to be back here again with you today. Thank you very much for joining. We are of course looking at the new Building Safety Act 2022 today, which achieved royal assent back on the 28th of April. And as it has such wide-ranging implications for the construction industry, we thought it was timely to have a look at that today. And what you need to know. So I'm very pleased to introduce to you today our three panelist speakers. Firstly, we have Fenwick Elliott's partner, David Bebb. David is a highly regarded construction lawyer who specializes in both domestic and international construction and engineering projects. He advises across a broad range of industry sectors on both non-contentious and contentious matters. And joining David today, we are delighted to have Simon Kerry and Michael Levenstein of Gatehouse Cambers, both of which are barristers who also specialize in construction, energy, and infrastructure projects, and amongst other various aspects of tax, insurance, and insolvency law, both of which who are regular speakers, publish regularly, and indeed are joint editors of the Construction Contractual Handbook. So welcome very much, Simon and Michael. It's very fantastic to have with you here today. So what we're going to look at over the next course of 45 minutes, and then we'll take some questions at the end. First, Simon is going to have a look at the reforms affecting claims and liability, extended limitation periods under the Building Safety Act, building liability orders, the Building Act, and the new construction cladding product causes of action. So after Simon, Michael is then going to run us through further very important aspects of the Building Safety Act, including higher risk buildings, the various duty holders under the Act, and of course the golden thread regime. And finally, Dave will look at how some of the provisions of the Act will impact future projects and how these could be addressed in building contracts, all with some very practical tips to take away, and no doubt it's going to be a fantastic discussion. So thank you very much to the three of you for joining us today. And before I hand over to Simon, just a few admin points that we generally go through. Everyone is on mute, so not to worry about that, but just a reminder to please do ask questions as we go along. You'll see a toolbar on the right-hand side of your screen. Do pop the questions into there, and we'll take a couple of those at the end, time permitting. And also rest assured that the perennial question we get always is, yes, absolutely, a copy of these slides and an on-demand recording of this session will be available on our website shortly in due course within the next few days. So with that, thank you everyone again for joining, and I shall pass over to Simon.
Thanks, Stacey, so much for that introduction. That's really helpful. So yeah, I'm going to be discussing the reforms in the BSA insofar as it relates to claims. And I think the best starting point is just with a brief recap of the position as it stands before the Act. So when we're thinking about claims in relation to defective buildings, and I suppose most particularly cladding, this is the framework that we are used to working with. And broadly, there are three routes to recovery. You have claims in contract, claims in tort, and claims under the Defective Premises Act 1972. Now, each of those causes of action have inherent obstacles that present difficulty for prospective claimants. Claims in contract, of course, that only works if you have a contract in place with the party that did the defective work. If you're a third-party purchaser of a building or of a flat, it's unlikely that you'd have a claim against the contractors or subcontractors responsible for the defects. Claims in tort, well, if the building in question is merely defective, the law says that those defects are an economic loss rather than physical damage. And as such, it's unlikely that any common law duty of care will be owed. As for the Defective Premises Act 1972, well, the duty here is only owed in respect of provision of a new dwelling. If it's work at refurbishing an existing dwelling, but no new dwelling with its own identity is created, that isn't covered by the Act. And in addition to those sort of specific problems, there are two overarching obstacles to any claim. And the first is limitation. Many defective building claims arise in relation to work done many years ago, which have perhaps come to light through investigations post-Grenfell, and those claims aren't necessarily going to have limitation problems. The second is what I've called insolvency, or the corporate veil. As you'll know, it's very common for construction contractors to manage projects through special purpose vehicles, companies that are set up specifically to deal with that project and are funded only to the extent necessary to deal with that project. So even if you do have a claim, you're likely to find that the defending entity has no assets and may even no longer exist. So that's sort of the existing landscape, and it's an unattractive one, at least as far as claimants are concerned. And the Building Safety Act seeks to address these problems by providing claimants with a number of new routes to recovery and also making provisions for more extensive limitation periods. There's reforms to the Defective Premises Act, there's new rights of action in respect of construction products, new provision for building liability orders, and also, while not part of the new Act itself, it's been announced that in tandem with these reforms, Section 38 of the Building Act 1984 will finally be brought into force. So let's just take a quick look at each of those. The BSA introduces a new Section 2A of the 1972 Act, and that imposes a duty on any person who takes on work in relation to any part of a relevant building. And that's a building containing one or more dwellings. That's considerably wider than the existing duty under Section 1, which, as we've already touched on, only relates to provision of a dwelling. How significant is that difference? Well, I think it's worth reflecting that the residents of Grenfell Tower were not owed a Section 1 duty, because the cladding in that case was put up as part of the refurbishment of an existing tower block that had been built in the early 70s. By contrast, they certainly would be owed a duty under the new Section 2A. In terms of the content of the new 2A duty, perhaps unsurprisingly, it mirrors exactly the wording of the existing Section 1 duty. It's to see that the work is done in a workmanlike or professional manner with proper materials, and so that as regards the work, the dwelling is fit for habitation when the work is completed. And of course, the Court of Appeal has told us that that is a single composite duty. So in any case, the claimant has to prove that the dwelling is not fit for habitation. Liability under 2A is only in respect of work completed after the section has come into force, which is 28th of June, 2 months after royal assent. And so that, in a nutshell, is the reform and broadening of the Defective Premises Act. Moving on to the Building Act 1984, Section 38. This is a provision that's been enacted for a very long time. In fact, it goes back even further than the 1984 Act and was included in previous legislation dating back to 1971. But in all those years, although it was enacted, it was never actually brought into force. Very simple provision. It just says that breach of a duty imposed by building regulations is actionable insofar as it causes damage. So it gives claimants a direct right of action for breach of building regulations. That raises a question: what is it that constitutes damage in this context? And the 1984 Act doesn't particularly help us with that question. Section 38(4) says that it includes death or injury to any person. Now, in light of recent events at 10 Downing Street, there's been some renewed debate as to whether the UK should introduce a written constitution. Now, if such a document were to be created, I think we need to find space in it somewhere to outlaw statutory definitions that begin with the word includes, because in my view, they're almost completely useless. So we know from this section that it includes death or personal injury, but does it extend beyond that? And if so, how far? We don't really know. The government fact sheet on the new reforms, which of course isn't a binding source of law, but let's just stick with it for now, says that this relates to physical damage, i.e. injury and damage to property, but not purely financial loss. And that's obviously a significant limitation in light of the point that we discussed earlier. Pure defects in a building are generally regarded as economic loss rather than physical damage. Section 38 of the Building Act isn't actually touched by the BSA itself. Rather, the government announced that they would bring it into force in tandem with the BSA reforms. And it was supposed to be happening on the 28th of June alongside the changes to the DPA. Now, as far as I'm able to discern, that hasn't actually happened, possibly because the government has had other things on its mind for the past couple of weeks. But in any event, when this does finally arrive, liability will be prospective. It will only relate to matters arising from the date when it's brought in onwards. So all of that is section 38. We now come to two new causes of action created by the BSA relating to construction products and cladding products. The first of these is governed by section 148, and it applies in three different sets of circumstances. First is where a person fails to comply with a construction product requirement in relation to a construction product, and that's defined by reference to various sets of regulations set out in the Act, including a power to make new regulations that will engage this section. Second, where a person who markets or supplies a construction product makes a misleading statement in relation to it. Third, where a person manufactures a construction product that is inherently defective. And in each of those sets of circumstances, liability attaches if, as a result of those matters, the construction product is used in the construction of a building, which, as a result, is unfit for habitation. The Act sets that out in rather more convoluted terms, but that basically is the essence of it. What is the consequence of that? Well, the person in question is liable to pay damages to a person with a relevant interest for personal injury, damage to property, or economic loss suffered as a result. And it's interesting that here liability is specifically extended to economic loss. That's in contrast with section 38 that we just looked at. Liability under this section purely prospective, so only matters arising after the Act's brought into force. Now we then come to section 149, which is almost identical to section 148, save for two important differences. The first is it applies specifically to cladding products and cladding product requirements rather than construction products more generally. And second is that this one applies retrospectively. We can see that from the words highlighted at the top, at any time before the coming into force of this section. Now, obviously, that possibility for retrospective liability is a significant concern to potential defendants and is a departure from what is the usual position. Potentially quite draconian in light of the very long limitation period that applies to these claims. You can go back up to 30 years. There is, for that reason, some additional protection for defendants in the form of a provision that the court must dismiss a claim under this section if, but for that very long limitation period, the claim would be statute barred, and allowing the claim to continue would breach the defendant's convention rights. Obviously, primarily they're thinking about their right to a fair trial. Other than those differences, the provisions are functionally exactly the same as section 148. So that's a high-level overview of those new product causes of action. Building liability orders. This is a new mechanism designed to address that problem we identified at the outset of construction projects being managed through SPVs and claimants not having a practical route to redress as a result. Gives the court the power to make a building liability order where it is just and equitable to do so. And it's simply an order attaching a relevant liability of one company to another. So if you can't recover against the original company, the primary defendant, for whatever reason, this gives you a route to going after others. What's a relevant liability for the purpose of this section? Well, it's a liability under the Defective Premises Act 1972, a liability under section 38 of the 1984 Act, or a liability incurred as a result of a building safety risk. And that's defined as a risk from fire or from structural collapse. The companies that can be subject of such an order are associated companies, that's parent companies, those either controlling or controlled by the original entity, or sisters, so those under the common control of a third company. Just note that the subject of a building liability order can only be a corporate body, can't use this mechanism to go after directors or individuals. That brings us to limitation periods. The BSA in a number of areas provides for significantly extended limitation periods. It's important to note that in terms of the general position in relation to claims in contract and tort, the BSA leaves the position unchanged, so it's no help there, but it does give significant assistance in other areas. So far as claims under the DPA are concerned, the limitation period both for claims under Section 1 and the new Section 2A is extended to 15 years going forward. And you can also now go back 30 years on a Section 1 claim, and that applies retrospectively. Limitation on a claim under Section 38, when that comes in, that's also extended to 15 years. And the new construction product causes of action, 15 years prospective limitation and 30 years retrospective in relation to cladding products specifically. So that is a bit of a whistle-stop tour of the reforms brought in by the BSA. Just before I hand over to Michael, I just wanted to touch upon a number of perhaps problem areas, because certainly the intention behind this legislation is a noble one, but I think there are quite a lot of areas where the statutory text is open textured. And I think we're going to see a lot of development as cases work their way through the courts. So just a few examples of potential problems that jump out at me. When will it be just and equitable to make a building liability order? The Act doesn't help us beyond those three words. And the courts have been saying for well over a century that using separate corporate vehicles is an acceptable way for parties to manage their risks. Piercing the veil, of course, is traditionally very difficult, so the courts are going to need to work out some sort of principled approach for addressing this question. Also in relation to BLOs, what's a liability incurred as a result of a building safety risk? How does that map onto, for example, contractual claims in relation to technical breaches of building regulations? How big a risk of fire or structural collapse is needed in order to satisfy that requirement? And looking at the new construction product causes of action, one of the routes to recovery is that the defendant has made a misleading statement. Okay, well, what does that mean? And do they have to knowingly have sought to mislead? Or is it enough if they say something that they genuinely believed, but that subsequently turned out to be wrong? What about corporate knowledge? So a circumstance where your sales executive says, well, this insulation is of limited combustibility, genuinely believing that that's true, but elsewhere in the same organization, the testing division knows otherwise, but hasn't divulged that information. And of course, there is a whole raft of potential practical problems, particularly arising from the very long limitation periods. If the courts are dealing with a claim from potentially 1992, almost certainly most or all of the key witnesses will have moved, retired, at least some of them have probably died, records may well have been lost or destroyed, and several of the corporate entities involved may well no longer exist. So how is the court going to unpick all of that? There will certainly be challenges, and I will leave you with that thought and hand over to Michael.
Thank you, Simon, and good afternoon, everyone. Today, I will be tasked with distilling the Building Safety Act down to its bare essentials. I welcome a challenge, so when Dave asked if I could try and do so in only 15 minutes, I couldn't say no. I'd like to begin by looking at the Building Safety Regulator. Part 2 of the Act contains its first major proposal, which is the establishment of a new National Building Safety Regulator, or BSR, to enforce the regulatory regime for all buildings. Under Section 3(1) of the Act, and I quote, "The regulator must exercise its building functions with a view to A, securing the safety of people in or about buildings in relation to risks arising from buildings, and B, improving the standard of buildings." The BSR will sit in the Health and Safety Executive and report to the Secretary of State. And the BSR's core statutory functions are to lead the implementation of the new regulatory regime for so-called higher risk buildings, which I'm going to come on to shortly, and to oversee the safety and standard of all other buildings. Some other building safety regulator duties of which you ought to be aware include, most especially, its enforcement powers. The Hackett Review had found that the current enforcement powers did not act as a sufficient deterrent to the industry. Consequently, this act provides the regulator with additional powers, which include the use of compliance notices and stop notices. Now, these notices can be issued where it appears that a party may be contravening building regulations and requires them to remedy the contravention or to cease work. The BSR is given extra teeth by virtue of Section 22 and Schedule 2 of the Act. These provisions give authorized officers of the BSR investigatory powers to uphold building safety. Under Section 24, the provision of false or misleading information to the regulator makes someone liable to imprisonment for a term up to 2 years. Let's talk about higher risk buildings. Parts 3 and 4 of the Act introduce this concept. Now, there are two subtly distinct definitions of higher risk buildings in the Act, one for the purposes of Part 3 and the other for Part 4. The bulk of Part 3 amends the Building Act of 1984 to enable the BSR to be the building control authority during the construction of higher risk buildings. For the purposes of Part 3, a higher risk building is A, any building of 18 meters or 7 stories and above, and B, contains at least 2 residential units, or is a hospital, or is a care home. Part 4, in contrast, creates a new building safety management regime, which applies to building owners and landlords after construction of the building is complete, or to buildings at the time of the Act coming into force have already been completed. Per Section 65 of the Act, a higher risk building for the purposes of Part 4 is any building that A, is at least 18 meters in height or has 7 stories, and B, contains at least 2 residential units. Note there the omission of hospitals and care homes. Central to understanding this framework is the role played by duty holders, to which we now turn. Now, this concept is broadly based on the duty holders from the design and construction phase under the CDM regulations of 2015. The duty holder scheme applies to all buildings, not just high-risk buildings, and it's based on the notion that the person who creates a building safety risk ought to be responsible for managing that risk. The key new difference is that there will now be duty holders with obligations regarding building safety from the planning phase all the way to the building's occupation. Duty holders will therefore be under an obligation to manage safety risks during the design, during the construction, and during the occupation phases of a building. And the key duty holders and their obligations are actually spelled out in secondary legislation, namely the Building Appointment of Persons, Industry Competence, and Duty Holders England regulations of 2021. And the main duty holders prescribed in that legislation are the client, the principal designer, and the principal contractor. A couple of the more specific duties of which you ought to be aware include that a designer must not start any design work unless they are satisfied that the client is aware of the duties owed by them for the building work. And under Section 39 of the Act, anyone who contravenes these regulations commits a criminal offense, which could lead to a fine or, again, imprisonment of up to 2 years. Let's now briefly turn to the golden thread, which has been talked about a great deal in the context of this legislation. And in essence, it requires the original client to make arrangements for an electronic facility to be maintained, which contains the golden thread of information. What is that? It's information about a building that allows someone to understand that building and to keep it safe. And the information management system, to ensure the above information is accurate, can be accessed by those who need it, and is up to date. Its purpose is to ensure that there is a single record of a building's safety information, which can be passed down and utilized by different duty holders from the original client down to whoever is occupying the building. And the government intends for the documents required within that golden thread and throughout 3 gateways, which Dave is going to be talking about, to include, for example, such things as fire and emergency files. The golden thread, it is hoped, will prevent new owners having inadequate information about aspects of the building which relate to fire safety, such as the installation date of fire doors or the building's materials. I'd like to now talk about accountable persons, and specifically the role played by a duty holder in the context of an occupied building. So when the duty holders, such as the client, the principal designer, and the principal contractor, are no longer involved with the building, the accountable person will be the duty holder with statutory responsibility for the building's safety. So, who is the accountable person? Section 72 of the Act establishes the role and defines it thus: either A, a person who holds a legal estate in possession in any of the parts or common parts of the building, or B, a person who does not hold a legal estate in any part of the building, but who is under a relevant repairing obligation in relation to any part of the common parts. And in the majority of circumstances, it will be the landlord who is the accountable person, but could also be perhaps the management company, especially if that company has a repairing obligation or are the occupiers of the building, for example, where they share ownership of the freehold. So that's the identity of the duty holder. What about their specific obligations as an accountable person? Well, the key duties include managing these building safety risks, and if needed, by carrying out works on the parts of the building for which they are responsible. And that duty is enshrined in Section 84 of the Act. And it may mean that these accountable persons can be held liable financially for quite expensive repairs to the building. And finally, it's worth considering what happens if the accountable person fails in these duties. Well, failure to follow these requirements may result in the BSR issuing a compliance notice against them, contravention of which can constitute a criminal offense. And corporate officers can be held directly liable for offenses of corporate landlords. So quite a bit to consider in light of the severity of the consequences for non-compliance. Now, mercifully for all of you, that brings my part of the talk to a close, but having saved the best for last, we are now going to hear from Dave, who has the toughest assignment of today, which is explaining what all of this means in actual practice.
Good afternoon. Thank you, Michael. Okay, so I'm going to focus on this in terms of how the legislation affects future projects. So I'm interested in my client, whether that's a developer, main contractor, or an architect, member of the design team. I'm interested in, are they going to make money out of the project, or another way, not lose as much money as they might otherwise do? I want to make sure they go into it with their eyes open and spot those potential trip hazards. Okay, item 2, it's a bit of a moving target. Some of these provisions are not actually enforced yet. It could be a way off, and we're not seeing these addressed in building contracts yet because it's quite a way off. For those of you used to Fenwick Elliott webinars, the slight problem there is I've got no war stories and sort of shared experience to share with the audience. We haven't got experience of this just yet. It's all very new to everyone, which sometimes can make a webinar a bit difficult where we can't plug in a sort of real life example to what's happened on a real life site, but we'll have to cover that in future webinars. I think the most important thing to point out is that I'm looking at this from a lawyer's perspective. I think this is the biggest bit of legislation to impact the construction industry for quite a while. If you think back on some of the other major construction legislation, think about the Construction Act. What happened then was that all these lawyers went away and drafted payment provisions and dispute provisions to comply with the Act. And we gave all the project teams the construction contracts, and they said, great, thanks for that, but we're still going to build the same way we're going to build, albeit something in the QSing bit and the estimating bit needs to do with payment slightly differently. So it didn't affect actually what was built or how it was built as much as this will. This really impacts how it's built, how a project gets to site, how it's managed on site, how change is managed on site, and how it is handed over. So the point, I think, for all those involved at the beginning of projects, whether that's lawyers, programmers, package managers, estimators, they need to understand before pricing a project what actually is the impact of this legislation on my job before I start it or before I price it. Okay. Item 5, I'm going to cover these gateway systems a little bit. I'm going to cover the change management process of when it's on site. And what that will hopefully become clear to our listeners is there is a risk of delay, both starting on site and during on site, and how we manage the change process. So in terms of disputes, all the usual suspects, okay? It'll be all the same things that could cause problems. I'm not going to focus on any particular form of contract. The principles apply to all, whether that is main contract, professional appointment, subcontract. I may tend to focus a little bit more on the employer-main contractor relationship, but think wider than that when I am talking about it. Okay, so the Building Safety Act is a huge piece of legislation. Okay, for those interested at how we look at future projects and how we price them, there's one bit I think that's worth reading and having to hand, and it's this bit of regulations. Okay, again, it's the most useful read in terms of what you need to think about versus how we've always priced and got jobs to site and managed them versus what the new regime allows. Okay, that's the most important. It's about 30 pages long. That's what you want on your desk out of all the hundreds of pages. Okay, Michael's already touched on what a high risk building is. Little point bullet 3, it's important to remember that the regulations will apply to HRB work. I think there's a tendency to think we're talking about new build work, brand new residential blocks going up. That's not the case. Look at how HRB work is defined. It's not just the construction of a higher risk building. It's work to an existing building which causes it to be higher risk or a change of use. Just think practically. Think of all the projects across London where residential blocks of flats have had additional stories added to buildings. That brings it within the scope of HRB work. The reason that's important, and I'll come on to this later, is because the impact that an existing building has on design. An existing building has a habit of throwing up some sort of swerve balls as to how we deal with it. And there's a concept later when you need to go back into the building regulator to get that change approved. Okay, so what this does is replace the deposit of plans system or the plans check system with a whole new regime. Now, the old regime, I think, was around about 5 weeks to get to that stage. And the new regime, we will see, is a bit longer. What we now have, and when you've got your copy of these regulations on your desk, there's around 30 items we have to tick off the box before we get building control sign up or building regulator sign up. The reason that's important is this gateway 2 is a hard stop. We cannot start work on site until we've cleared this gateway 2. Okay, so there's more information to do. And it's a longer period of time. Look, it's 12 weeks. I think even the 12 weeks is in square brackets at the moment. There's a lot of this legislation that's still in square brackets. And one of my colleagues quipped saying there's more square brackets in this legislation than in your usual drafting, Dave, because it is. It's just taking shape over time. Okay. I think the most important thing here for anyone, particularly for the lawyers, the most important thing I think to do is if my client was an architect or a contractual developer, I would sit down with a copy of these new requirements, these 30 items, and I would say, read this with me and tell me how much more work is involved versus the current scheme. How much longer will it take? Can we compress that? Where do you see the trip hazards or the grey area? And more importantly, how have we priced and programmed it? Merely saying I'm going to price for compliance with the new Building Safety Act seems to me commercial suicide. You might see it written like that. It's far more difficult than that, or it's far more nuanced than that. There's quite a few grey areas in there which will only sort of develop over time. So we've got actually a concept of these 30 items as to what we need to do to get to Gateway 2. And there's a schedule in there that sheds some more information on how we might write a construction control plan and what it needs to cover, how we might cover or draft a design and build approach document. Now, some of the design team might say, Dave, we've been doing that for years. We don't see a problem there. Some of my design team or contractors might say, actually, the way this is written requires a lot more work, Dave. Okay. Even the building, there's a fact sheet that I think Michael referred to earlier in terms of how the government intends it to work. Look at it from a lawyer's point of view. Building regulations considered holistically, outcome focused, realistic and unreasonable assumptions. It's all sort of stuff that lawyers think, what do I actually have to do to tick a box to get through my gateway 2? Because I can't start until I've done it. I think you say a lot of design teams will have a pretty good idea as to what that requires, but I would like to sit with them and say, how much more work do you think is required in doing that? Okay, so if you want to read it, the relevant part is part 3 of the regs. It's about 5 pages about how we get through this gateway. If the design team and the contractors turn around and say to me, Dave, there is quite a lot more work involved in developing my design before I can start, what does that do to the sort of usual position of the UK construction industry, which I think is fair to say, the race to site? How quickly can we get to site? Well, now, if we've got a situation where we've got this much more work to do and a longer period of time for the building regulator to sign off on it, what do we need to do to still hit the same start date? There's been all sorts of talk about this might be the end of sort of design and build construction. There might be some more 2-stage construction involved because we need far more input from my contractor to clear this process. Who knows? But there's a few things that occur to me that I would want to put in there for my client to make sure that I've priced it properly. Item 1, a very clear set of who's responsible for doing what to get through gateway 2 and the assumptions made. Remember, this is a more comprehensive process and potentially, well, it is a brand new process for the building regulator. And the building regulator, point I mentioned later, have we got enough people to actually fulfill this role? Where's the real risk? Well, the real risk is it's a learning curve. There's more work involved, but there's a start on site date that everyone's got mentally in their mind when they want to start. Item 2, what's the implication of the gateway 2 not being passed because of an employer issue? Will the existing contract cover that? It might do. Well, if I'm a contractor, to say that was your responsibility, client, under that little matrix of responsibility bit that we've got in our contract, that's your lookout. Again, we can't start work until gateway 2 is passed. Do I need something very clear in my contract that says we cannot start work until gateway 2 is passed? That's no different to bits of the CDM regulations already. Item 4, there is an element of the Act and the regulations that sit behind it that allow staged approval. So let's take a typical example. Let's say there are 4 residential blocks on a site, and I'm going to build them in a sequence. If I go in for my building regulation approval on block A, I can submit all the information to the building regulator and they say, great, good to go. At that stage, the design may not be developed enough for blocks B, C, and D, and I can put a lower threshold of information in and provide that information later. Okay, that's great, but again, really practically, once that site is up and running block A, all the facilities and the premiums are serving or will be serving all those other buildings. So my clock and money is being burnt as soon as I start block A, but I still haven't got building approval to carry on with blocks B, C, and D. Okay, so again, I'm trying to focus the fact that anyone advising on this has really got to look at the actual specifics of the project to see how this legislation will impact it. Okay. There's a provision there to agree longer than the statutory 12 weeks. Well, it begs the question, why was agreement needed? Was it your fault or your fault? Item 6, a point I've already touched on. Are there enough building control officers to actually manage this? Yeah. Will there be sufficient resource? I think generally, there's quite a shortage of qualified people who think they're going to do this role. So whilst there is a statutory limit mentioned of 12 weeks, what are the chances of that being met? Now, a typical building contract might say if there's a delay in approval by a government body or by the building regulation, that might give time but not money, but it's all got to be thought about. So I think I had the wrong slide there for you, sorry about that. Okay, so again, plugging in this to a real job, what's the implication of refusal by the building inspector, by the building regulator rather? Hopefully a low risk. More likely might be approval subject to various requirements. There is an ability for the building regulator to say, yes, you can go subject to the following. Now, there's no, the way the regulations are written is there's examples of what obligations and requirements the building regulator can impose, but it's not an exhaustive list. One of them is provide certain information with a specified period of time, or you can only progress this far with the work before coming back, but it's not an exhaustive list. So again, what likelihood, in our experience, what do we think the building regulator may insist on, or what conditions might be attached to it? Item 8, they can tell us we can only proceed to a specified stage before we have to go back, or certain work is not covered up. Can probably be managed fairly well, I would have thought. But I think point 9, just to reinforce it, I keep making this point, but it's really, really important. I think advisors or programmers, estimators, anyone commercial really understands how much more work is involved and where those trip hazards potentially are going forwards. Okay, right, so let's assume that we have managed to clear Gateway 2 and we are up and running, okay? Understandably, the legislation having focused on what we have to do and the level of design we get to before we start, it would be a nonsense if once we've started, we can make a load of change during the construction phase. So there's a very detailed process, look in regulations 11 to 18, as to how change control is governed. Now, this is potentially even more of a source of problem, isn't it? Because once I'm up and running, the site is going, the money's been spent, and the clock is ticking. So as soon as we want to make a change, or as soon as the building throws up something which requires a change, what have we got to do? Okay. So in item 3, the current legislation is written such that any change that is something that is otherwise in accordance with the current plans. That's quite wide, remember, especially when you see it in context that my plans to get through Gateway 2, I think, if my design team tell me, have got to be more detailed and more comprehensive than they were under the old regime. So any change to the current plan seems to me a real source of a problem. So these controlled changes, there's 2 types of change under the legislation. Now, they're not defined yet what they are, but there's a concept effectively of a threshold. There's a notifiable change. I need to make this change, and I've got to wait 14 days before I can proceed. Well, there's a major change when I cannot do anything until the change application control is granted, i.e., I send all the documents in, and I say, look at item 5, I say this change is needed. The existing building threw up something that I didn't see coming, and therefore the design's got to change. Who's advised on it? Well, I've got all the information from the structural engineer, all the information from the fire engineer. This is why we think the change complies, and here's all the information you need. It's all part of the same point, the golden thread that Michael mentioned. There's then got a 4-week period to determine that change control application. So just think of the potential risk of that on site in terms of, right, if it is one of these major changes, what happens? So what does my contract need to say in terms of how change is managed during construction? Well, it's very many of the same issues that cropped up in terms of pre-Gateway 2, isn't it? Is that how much information does the building regulator want? How long has the building regulator got to do it? All these things apply equally, it seems to me, on site as they do before site, but the potential cost implication while the project is ongoing must be greater. Must be greater, because at least if I'm delaying my start on site, whilst it's most frustrating for the developer, once building work has started and we're going in with change, it seems to me the financial consequences and the scope for dispute are much greater. Item 2, you've got to think about why the change was driven. Is it a client-driven change? In which case, does the risk of the building regulator sit with them? Is it a contractor-driven change? What is it, and how does the contract deal with that? How do we pick up the risk of design errors in the Gateway 2? So we've got through Gateway 2, but actually we find this design isn't quite going to work. Now, I'd imagine the contracts will be written such that whoever takes the risk of that issue takes the risk of then going back into the building regulator to say, this is my fix for that issue. Okay, we don't know. I think about how this design submission procedure works as well in terms of the timeframes allowed and assumed within the prices. That's something I think I'd be looking at in my contract. I think in terms of timing now, I was hoping to cover Gateway 3, but there's quite a bit in that, and I'm conscious it's sort of what 10 to 1. All I can say there is there's another regime where we get, so the way the gateways work is we can't start until gateway 2 is passed. We then have all this regime that governs it on site, and there's a whole regime that governs before the building is passed off fit for occupation, which is this gateway 3 system. The biggest issue there, I think the industry is thinking about there, is that, well, in effect, I have a building that in sort of old terms is PC, and under the old regime would have been building control sign off and a building ready to occupy. We now have this different regime now that is more comprehensive to get to PC or to get occupation, and there's a longer period of time before the building regulator comes back and says, yes, you can occupy. What happens? How does the contractor or the client allow for that 12-week program? Is 12 weeks just bolted on at the beginning? So I take my estimated PC date and I add 12 weeks. How does it work? We don't know yet, but I'm just conscious, Stacey, that it's 10 to, so we want a bit of time for questions. I might wrap up there, and I'm guessing we will have some more webinars on this safety bill or act rather, as we get a bit more information on it, and also as we have some more guidance. But otherwise, Stacey, I shall hand back over to you.
Absolutely. Excuse me. Thank you, David, Michael, Simon. That's been fantastic. Such a clear, I'm going to go with more than bare essentials of the Building Safety Act, but a really good coverage in the time that we've had here today. So thank you very much. So audience, thank you so much for the fantastic questions that have come in over the past 50 minutes. So many questions that we're definitely not going to be able to get to all of them. So I'm no doubt that Simon, Michael, and David will happily follow up afterwards to the extent that they can. But thank you very much for sending them in. So let's grab a few of them because I know, Simon, you need to end promptly. If we can come to you first. Because one of the questions that came in was around building liability orders. Will this apply to companies who contract out of work if the company you contracted to no longer trades, for example?
So short answer to that is yes. There's specific provision in the Act saying that an order can be made even where the original entity no longer exists, has been dissolved. So yes. Excellent,
thank you. And also, I think possibly if you could deal with, this question's come in several different guises about more or less, how can law be retrospective?
Gosh, okay. So
yeah, thank you.
Big question. So when a statute's passed, normally it would only apply going forward. So say a statute creates some sort of new claim that arises in certain circumstances. From that day forward, when those circumstances arise, a claim arises. Under most statutes, you can't, as a claimant, sort of go back into the past and say, well, all those circumstances happened to me 5 years ago, so I'm now going to come after a defendant based on something that happened before the Act was passed, right? But there's nothing in principle to stop statute being passed that allows exactly that, and says, no, this takes effect retrospectively as well, and allows a claimant to bring that kind of backwards-looking claim. Now, generally, that's not done, right? Because it's perceived as not very fair. You're potentially fixing a defendant with liability for something which at the time they had no way to avoid because they had no idea that it was something they'd be liable for. But it's perfectly possible to do it. So under the BSA, there's really kind of two types of retrospectivity that come into play, right? The first is the extension of limitation periods, for example, for claims under the Defective Premises Act. So what's happening there is you had a defendant that breached duties that were in force at the time at some point in the past, but then any claim against them expired because of limitation. And the defendant has now been stripped of that limitation defense, so a claimant can now pursue them in a way that they wouldn't have been able to. So you have a claim from the past that had fallen away that's now been resurrected. The second type is what we see in relation to the new sort of cladding product clauses of action. And here, the BSA creates an entirely new species of claim that didn't exist at the time work was done. But nonetheless, in the circumstances laid down by the Act, the defendant is retrospectively fixed with liability for that which it did. And you know, depending on the type of claim that you're talking about, could that be buildings that have been constructed, buildings that have been modified at some point in the past? it could be both. I mean, the Defective Premises Act applies to any work that's been taken on in relation to a building. So I hope that clarifies. It's unusual, it's controversial, but it is possible to have law that applies retrospectively.
Excellent. Thanks, Simon. That's very helpful. Michael, possibly if we could come to you next. We've had a couple of questions around the insurance sector. Can you consider the implications of the Act in the insurance sector? I know some of your practice deals with that as well, and in particular on PII.
Absolutely, Stacey. And it's a very timely question as to how the BSA impacts professional indemnity policies, which I'm happy to share a couple of thoughts about, as well as the intersection between that and the extended limitation periods. And the reason it's relevant, of course, is because there may be no insurance in place to cover the extended periods made possible now under the BSA, and parties often will choose their insurance period to cover the period of time when they consider themselves to be at risk of a claim. A further substantial problem is that developers may struggle to seek contributions or indemnities from parties further down the contractual chain. And owing to the frequency of insolvencies within our industry, after 20 or 30 years, many subcontractors will invariably no longer be active. And even if they are still active, the insurance may no longer be operative. And the upshot of all of that is that these extended periods could cause firms to declare bankruptcy and provide no resolution for the aggrieved parties. A further problem is, of course, what has happened to the DPA as a result of the Act, including the 30-year retrospective limitation and the 15-year prospective period for claims under Section 1, so that there'll be a far greater number of buildings which now fall within its scope. And to this, I would say there are two fertile areas of debate which those on the call today should be mindful of. The first is the debate which is inevitably going to ensue regarding whether the duties under Sections 1 and 2A of the DPA give rise to strict liability, which would create difficulties under a PI policy, which would only respond to negligence rather than strict liability, or if the courts are going to, as a matter of policy, decide that these offenses are subject to a reasonable skill and care obligation akin to negligence, and therefore within the ambit of professional insurance carriers, save for workmanship, presumably. We must watch this space. And I would also say, secondly, that as far as DPA claims are concerned, with their retrospectivity, those may still indeed be covered by PI policies, even if there is only a contractual policy to maintain PI for 12 years post-practical completion. 12 years, of course, being the limitation for contracts executed as a deed. And I say that there will need to be a burgeoning market for post-12-year periods because many parties that are still in business will be maintaining PI cover on a rolling basis long after 12 years, 15 years, 20 years, 30 years, especially if they have a very good reputation and presence in the market. And so they're likely to be covered by virtue of these policies rolling on from one year to the next and responding to DPA claims as opposed to simply contractual or tortious claims. But that may, of course, be reflected in higher premiums that are inbuilt into the PI policies more generally. It's something to be eminently mindful of, but of course, we're going to have to wait and see how it pans out in terms of the specifics.
Great, thank you very much, Michael. I think I can squeeze in one or two more questions. Actually, Michael, this next one will be for you. I think it's a really important one that we try and capture. Can you discuss a little bit further of the interplay between the Health and Safety Executive and the Building Safety Regulator? Does the Regulator replace the Health and Safety Executive?
Of course, again, a very sensible question in light of this new landscape. And the short answer is that the interplay, so far as I can ascertain, is as follows. The HSE has created the BSR to sit within it. And the new framework for high-rise buildings, as I defined in my part of the talk, 18 meters and 7 stories and above and so forth, is that the HSE is the statutory consultee for planning applications, and that the BSR will be the first line of defense as the building control authority actively surveying, inspecting, and approving works done on those high-rise buildings, but would nevertheless, within a framework, sit within the HSE, whose duties and role is more manifold than just looking at high-rise buildings, which is where the BSR really takes principal responsibility.
Great, thank you. Dave, you may not be surprised that we have a number of questions for you, but I think given the time, you're going to need to reach out to our audience separately. You might be able to answer one quickly. A number of people have had questions around, you talked about those 30 items. Look at those 30 items. Can you give a bit more guidance on where to find that? Have they been released?
Draft regulations. It is the Building High Risk Buildings England regulations. They're in draft. Should be able to find them on the government website somewhere. But they're also, I think there's a reference to them on the slides as well, Stacey.
Absolutely, thank you. That's fantastic. Thank you again to the audience for all of those questions, and we will reach out to you separately for the ones we have not tackled. So that brings us to the end of today's webinar. So it just leaves it to me, in the usual way, to market our next upcoming webinar. We are taking a short break in August, but we will be back with you in September for our next adjudication update. This will be number 2 of 2022, where we have Fenwick Elliott Senior Associates James Mullen and Adele Parsons, who will be joined by, be back again with us, if those of you who tune in regularly, Daniel Churcher, barrister at 4 Pump Court. So we hope you can tune in with us then in September, Thursday, 12 noon UK time as usual. And I've also, in the usual way, have given you the link there to our further newsletters if you so wish to subscribe to them. And in the chat, if you would like a copy of the slides, today's slides, as well as the on-demand recording, you will find those on our website very soon. So please do to look out for those. But in the usual way, thank you very much, Michael, David. And Michael, if you could please extend our thanks on to Simon, who had to cut out promptly at 1. Thank you very much today for taking us through the Building Safety Act. And thank you very much to our audience for joining us. We very much hope that we can see you in the very near future. So wherever you are around the world, thank you again and stay safe.